Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues, so please subscribe to our channel. Today we're going to talk about the sale of marital property in order to pay for your lawyer. Now, we're going to discuss it in two ways: before your case starts and after your case is over. A lot of times people will say, I don't have money to hire a lawyer, but we have some marital assets. Am I allowed to sell marital assets, which theoretically are joint, in order to pay for my own singular lawyer? It's a very good question. Here's the answer. Until such time as the divorce starts, everything is owned by both parties. That is marital assets. It's everything you bought, everything you acquired during the marriage, or any joint bank account, for example, belongs to both parties, which means both parties can exercise dominion over it, which means both parties could theoretically sell it and use it to hire their lawyer to get a divorce. You have to understand one thing, though. Since the item belongs to both parties, if you sell the car to pay for your lawyer, don't expect that the other party won't do the same. Or when the divorce starts, at least say, look, this property was sold, it's $10,000, but half that was mine. I don't want to pay for her lawyer, so therefore I want a $5,000 credit towards something else. And that may very well happen in that context. Now, what about a situation where the divorce is over? The profits have been split. The marital assets have been divided. What then? Well, the answer is then it's a much easier scenario, because in that analysis, whatever money is to be divided has already been argued before the court, and the court has made its decision and given this property to this person and that property to that person. If you at that point in time got your property and the divorce is over, and now you want to sell it to pay your lawyer, of course, there's nothing that prevents you from doing that. You can certainly do it. It's more of a question when no judicial determination has been made. And so now we know if we have something and we sell it, it is something that potentially the other side would have had an interest in. So you can well expect that down the line, the court will reconcile this. Now, if it's something that you did to get your lawyer and you started proceedings and you stopped, and then 2 or 3 years later you pick it up, I don't think the court's going to go back and say, well, wait a minute, this belonged to you, this belonged to you. The court doesn't usually engage in that level of forensic analysis on a historical basis. But if it's something that you did and immediately after doing it, you funded the divorce, expect that the court's going to say, whatever's good for you to fund your lawyer is also good for the other side to do likewise, and there will be a reconciliation. If you have any questions about that, reach out. We'll be glad to help you out.